I conclude that the applicant has failed to meet the test for a reasonable apprehension of bias. Accordingly, I conclude that the application for my recusal falls to be dismissed, and it is accordingly dismissed. Yes, Mr. Pretorius.
Chair, during the course of the week, we have had various discussions both in chambers and during the course of address before you that indicated that the applicant and his legal team would react in one way or another, and perhaps we should find out what their attitude is. We, as a legal team, do have a position, and we've prepared argument on the eventuality of the result that has occurred, but perhaps that should wait, and we should hear my learned friend.
Okay, all right. Mr. Skakana.
Chair, I'm not entirely sure what Mr. Pretorius is saying. He says he will argue after me. I'm not entirely sure. I've noted the judgment. I don't know what he says I must say before he argues something. I'm a bit baffled about what he says we must argue after a ruling. I really don't know what he wants me to do.
Yes, well, I guess he should...
he wants to hear what I think.
He should carry on with his plans.
I think he must carry on with his plans.
Yes.
And I will say if his plans are not aligned with mine.
Yeah.
Thank you.
Okay, all right.
It seems that any attempt at collegiality, Chair, is not well accepted. Our position is the summons still stands, and the applicant, Mr. Zuma, must now answer questions. If that position is opposed, I will present argument to you on that basis.
Thank you, Chair. I'm clearer now about what it is we're debating.
Yes.
Well, I have no position to put for us to debate. One is that before we excuse ourselves from the proceedings, I think I have a duty to tell the Chair why we will excuse ourselves so that it's not called a walkout or defiance, but we will excuse ourselves right now. The first is this, is that the instruction is to review your decision that you've just made when you finally give us a copy. And we'll take it from there. The next, Chair, is that you will realize, maybe I didn't say this enough, is that you have become a judge in the dispute that involves yourself. In that you determine disputes that arise in matters that include you. And Chair, I know you quoted Arthur Chaskalson, the CJ, but you may have not noted that the issues in Arthur Chaskalson and Louis Late were common cause, and the issues here are not common cause. And for that reason, Chair, we're going to excuse ourselves from this proceeding so that we consider your ruling. And insofar as the issue of you becoming a judge in your own matter, which on its own is a ground that we've mentioned, that Mr. Zuma mentioned, I want to say that we've also been instructed to bring an application, not an application, to lodge a complaint about you in that regard to the Judicial Service Commission in respect of the issue about which you've made yourself a witness and a judge. And therefore, Chair, I have no other instruction today or anywhere in the future until we've considered the review, except that we would like to be excused from these proceedings. Thank you.
Okay. Mr. Pretorius.
Chair, we have prepared argument in writing to place before you. The effect of that argument is that notwithstanding an intention to review your decision, in short, the proceedings must continue. And if, as my learned friend puts it, they are excusing themselves from the proceedings, they are in fact acting, well, not they, the applicant would be acting in defiance of the summons and unlawfully. It's up to you, Chair, to decide whether or not the proceedings will continue or whether they will be adjourned or stayed, in effect, pending any application for review or any referral of any complaint, Chair. So the position is simply the summons stands. It is not, with respect to my learned friend, open to the applicant simply to, quote, excuse himself, unquote. The proper application of the law demands that you make a decision about the continuance of proceedings. And in that regard, we have prepared argument. But in the face of a unilateral decision, I'm not sure that it's going to be productive to take up time presenting that argument to you. So perhaps we should take the short adjournment and you can rule on the proceedings after the adjournment.
Well, let's take a tea adjournment and then we'll resume after 15 minutes.
Thank you, Chair.
We adjourn.